Bonjour. In a previous video, I gave a comparative perspective on judicial review of legislative action, distinguishing systems that point to the will of the people, referred to as demos, from those who favor the rule of law and therefore judicial review. I explained that European countries that returned to democracy after a totalitarian regime embraced judicial review, whereas France remained on a demos model. The move by France towards accepting a very limited review in 1958 and moving slowly to adopt a fully integrated judicial review in 2008 can only be explained by a unique national experience. France has experimented judicial review before its national revolution, long before Marbury versus Madison, but it was due to confusion of powers rather than attributable to the rule of law. Judicial review made a comeback after the Napoleonic era, but it vanished due to political instability. It reappeared timidly in 1958 for purely administrative reasons, and it was a long way until France finally shifted from a demos to a rule of law model. The name of a French ruler will be associated to each step in this fascinating journey. Step 1 starts with Louis XIV. In the 17th century, King Louis inherited a highly divided kingdom, where a number of vassals tried to be kings in their own province and subvert the royal power. Louis XIV took the following steps. First, he built the Versailles Palace, where he gathered the nobility, distracting them with pompous life, honors, and frivolity. 2, he expanded the intelligence service to hear of everything that happened in the smallest village. And 3, he made sure that any significant local or national edict was marked as reviewable by the king in his council, and no one else. Alexis de Tocqueville explains the matter in The Ancient Regime and the Revolution. Unless so marked, royal edicts could be reviewed by a horde of local courts. There was no central court to review their decisions. Each province had its sovereign court of justice, called a parlement, and staffed with members of the aristocracy who had inherited their seat on the court. Not only they could annul whatever was a threat to their privileges, but they also allowed themselves the right to refuse to register the laws they didn't like into their books. This was a confusion of judicial and legislative powers. Louis XIV had it that the King's Council was the only body to review any ordinance he deemed of importance. This was confusion of the judicial and executive powers now. Okay, if you are lost, you now understand why Montesquieu had to be born in France. Much was to be fixed. No wonder France had a revolution. Step 2, Napoleon. After the turmoil of the revolution, Napoleon created a centralized court system that France still has to this day, with some updates. The former King's Council had become a Council of State, Conseil d'État, with 2 missions. Task 1 was to advise the executive on legal matters and verify that executive orders would be bulletproof, legally speaking. Task 2 was the judicial review of administrative decisions, whether made by central or local government. Starting in the early 19th century, France developed the most robust system of judicial review of administrative action. French administrative law was developed by the jurisprudence of the Conseil d'État, which remains a model in many parts of the world. It has been a major source of inspiration when building the EU court system. It has inspired the development of administrative law in the UK, and scholars recommend that the US pay attention to it. Yet, listen carefully. The Conseil d'État reviews the activity of the executive branch, including regulations of national importance, but not the legislative branch. Typically, ordinary legislation is applied by ordinary courts. A Cour de Cassation, Court of Cassation, was placed at the top to hear of appeals by parties complaining that the law had not been properly applied. Now, unknown to many, in the early part of the 19th century, the Court of Cassation considered it a judicial duty not to apply laws that infringe the Constitution. This is described by Jean-Louis Alperin in The Triumph of Judicial Review, The Evolution of Post-Revolutionary Legal Thought, a chapter of comparative legal history published in 2019, a book of which I am the principal editor. Alperin shows that the Court of Cassation recognized the existence of a constitutional order, with one case in 1825 where a law was set aside for unconstitutionality, and two cases in 1851 where the court also reviewed the constitutionality of a legislative act, this time upholding it. With the advent of the Second Empire, the court no longer used this Marbury v. Madison approach. It would never come back, though it matched the spirit of the revolution and would have promoted the rule of law in a country that was shifting between democratic and authoritarian regimes. France had no less than 15 constitutions since its revolution and no judicial review between 1851 and 1958. I come now to step 3. Charles de Gaulle. He is known as the liberator of France and made a point that France be on the side of victory at the end of World War II. Because France proclaimed that the Vichy regime collaborating with the Nazi was an illegal regime, the country did not feel compelled to create a constitutional court like Italy and Germany. De Gaulle's point that France had been liberated by its own people with the help of the Allies, an opportunity for me to thank the American people. The demos prevailed over the rule of law. In 1958, in the wake of France's last colonial war that led to the decolonization of Algeria and much of Africa, France went through a regime change with a new constitution, the Fifth Republic. It diminished the powers of the legislative assemblies and strengthened the executive, actually splitting the legislative power between the assemblies and the executive. A bit like the US Constitution, Article 34 lists matters that fall within the powers of the Parliament. Remaining powers are devolved not to the states, for France is not a federal state, but to the executive that can exert them by executive orders. An arbiter was needed to make sure one power would not step on the jurisdiction of the other. They created a constitutional council of 9 members. At its inception, the Constitutional Council was a behind-the-stage institution, arbitrating jurisdiction issues that did not interest the public. Progressively, it determined broader issues, declaring that it could strike down any legislative act infringing not only the Constitution itself, but also any text referred to by the Constitution, such as the 1789 Declaration of the Act of Man and the Citizens, the French Bill of Rights. Decisions by the Constitutional Council took more and more political and legal significance, but there were institutional bottlenecks and shortcomings. First, members are appointed for 9 years, 3 by the French president, 3 by the President of the Assembly, and 3 by the President of the Senate. They are picked based on political affiliation rather than legal skills and experience. It is something viewed as a pre-retirement benefit for senior politicians. Former presidents of the republics are members by law, a way for them to receive compensation when leaving office. Second problem, the review as set up was only abstract, as explained in my previous video. The petition had to be made after the vote of the Legislative Act and before the President would sign it into law. This means a narrow window of 2 or maybe 3 days. After that, too late. The people had to live with an unconstitutional enactment until representatives of the people decided otherwise. Third issue, only 4 political officials had a petition power: the President of the Republic, the Prime Minister, the President of the National Assembly, and the President of the Senate. Yes, de Gaulle was a demos person. The way to judicial review was a narrow door, and it was not properly judicial. It looked like a committee decision made behind closed doors, with a decision reading like very sketchy minutes. I come now to step 4, Valéry Giscard d'Estaing. In 1974, the French elected a more progressive president, ending the Gaullist period. By way of constitutional revision, access to the Constitutional Council was enlarged. The petition power, the French use the word saisine, was granted to a group of National Assembly representatives, les députés, or senators. A minimum of 60 signatures was required. That was a big deal at the time, in the sense that it opened the access to review to representatives of minority parties. However, it further politicized decisions, the council being described as a sort of third house, in addition to legislative approval by the National Assembly and the Senate. A breakthrough was needed to move from a system of political review to proper judicial review. François Mitterrand, the French president between 1981 and 1995, strongly advocated a system of constitutional court like in Germany and Italy, but he lacked political momentum. That brings me to step 5, the final step. Nicolas Sarkozy. 1 year after his election as president, a constitutional reform passed, giving constitutional value to the Charter for the Environment and giving petition rights for review to the citizens, like in other European countries. The constitutionality of the provision is discussed in the ordinary court in the context of a case, but the judge cannot rule on it. The court can mitigate or eliminate the problem, choosing an interpretation that does not harm a constitutionally protected interest. It cannot strike down a provision on ground of unconstitutionality. Only the Constitutional Council can do this. For this to happen, parties have to appeal all the way up to the Court of Cassation, and if convinced that there is a constitutional issue, the court refers the case to the Constitutional Council. The Council can annul the unconstitutional provision or order it to be interpreted in a constitutional manner. When the law needs to be changed, the Constitutional Council mandates the change to take place by a certain date, also to mitigate the inconvenience of retroactivity. The Constitutional Council no longer meets in a conference room, but now in a proper courtroom built after the revision. It hears arguments by the parties and by the government. This is becoming true judicial review. The next step will be to revise the composition of the Council, making sure that all members have high judicial experience. This also means the ousting of former presidents of the Republic from its membership. In the past, they made them life senators so that they could remain on the payroll. I would rather pay them on the condition that they do nothing. It may be a low cost to pay to eliminate a remaining vestige of confusion of powers. Thank you. Je vous remercie.